Hello, and in this video we're going to be looking at subjective recklessness, reckless manslaughter. So let's put things in context. So we're looking at a case of homicide where somebody has killed someone else, i.e. murder and manslaughter. And then we're looking at a case where the defendant, he lacked malice aforethought, which is basically the mens rea for murder, and the courts interpret this to be the intention to kill or cause grievous bodily harm. This means that we're looking at manslaughter, and there's two types of manslaughter, voluntary and involuntary. Involuntary is where this malice aforethought is missing. And there's three types. Constructive manslaughter, where you basically construct the manslaughter conviction out of another less serious criminal act. Gross negligence manslaughter, where it is a negligent act that's caused manslaughter, but it's so gross that it's made into a criminal conviction as well as a civil action claim. And the final one is subjective recklessness. Now, I've done a dotted line. I don't know if you can see, because it's not very clear for recklessness. But the idea is that a lot of academics say that this area is really interesting in the realm of academics, where you look at different ways of killing, the different types of mens rea, but in reality it doesn't really exist. Because what is reckless manslaughter? This is essentially where basically you have the foresight and you know that somebody can possibly die. There's a serious risk that they can die or get seriously injured from my action, but you still go ahead and do it. And in a sense, this is basically similar to when you're looking at constructive and gross negligence. And in reality, these two offences seem to cover everything as opposed to having a reckless manslaughter on its own. Nevertheless, it is still important because it was mentioned in Lord Hope's thorough analysis on the different forms of manslaughter in the Attorney General's case number 3 of 1994-1997. So it's still important. And the case, like we looked at in gross negligence, was Adumaku. The case here is R and Leida 2000, where basically the defendant had an argument with the victim, who was kind of half leaning into the defendant's car, but then he drove off. Basically, the wheel then crushed over the victim, and the defendant was convicted of manslaughter. And the Court of Appeal said, did he foresee the risk of death? Did he assess that this is quite likely and still go ahead and commit the crime? That's basically subjective recklessness. There isn't very much to say on it because it always tends to be covered by constructive manslaughter and gross negligence. But we can look at a great case study of it in the offence of killing and while driving. So the juries tend to be quite unwilling to convict somebody who has run over somebody else, because I think they can connect with the driver more than they can connect with somebody who's a gun owner. So unless you've used the car as a weapon, they seem to be quite reluctant to convict. And this led Parliament to enact legislation to create a special offence of killing while driving, and this is covered under Section 2A of the Road Traffic Accident 1998. And like gross negligence, dangerousness is an actually I would say like constructive manslaughter, dangerousness here is an objective question, and you are looking at whether the driver fell below the standard of a typical driver. You can see it's combining both the manslaughter in a certain way, but it's interesting that this subjective manslaughter is kind of covered by killing while driving, because it's, you know, the risk of driving dangerously can lead to death, but you still went ahead and drive dangerously. It's significant because it shows that the law attaches a really big significance to consequences such as death, which happens in killing while driving, and this is why this act has come about. Secondly, the existence also shows the effects of society's attitudes that they can have. Because car crime is seen as less serious, the jury are less likely to convict. The Parliament has to step in to say, you know, no, this is wrong. And thirdly, I just think it's interesting because killing while driving isn't constructive manslaughter in a sense. Yeah, you're not constructing out of a theft or a different type of crime. It's not gross negligence because yes, you have a duty to other cars and other pedestrians, but you're not going through the full process. It's a strict liability case that if you are assumed that you know that driving dangerously has these consequences and you still go ahead and do it. Anyways, interesting topic. Thank you for watching.